Hi, Assalamualaikum. We are from Group 5. We'll be presenting about the case Billy versus Arthur Young and Rosenblum versus Adler. Our member group is Muhammad Adam, Muhammad Al-Amin, Hazira Umairah, Nur Syafiqah and Zafira.
Many people get interested to invest in Osborne Computer Corporation because they rely on unqualified audit opinion. It is also due to the warrant investors provided. Not long after that, the investors faced economic harm when the company went bankrupt due to poor business planning. So the plaintiff, the investors, brought an action against Arthur Young, the auditor, because he is liable for alleging intentional fraud, negligence, misrepresentation, and professional negligence on unqualified audit opinion that contain errors.
Argument Billy versus Arthur, judge should consider economy before rule. Audit firm is important in capital market, thus when auditor was guilty, it will become a business hazard. Client will sue the firm as they had a deep pocket. It gives impact on auditor profession as they must be trusted by public. Recommendation, proximity relationship must exist between auditor and third party. Although no direct contract between them, auditor owe Billy a duty of care and the thought of negligence. Governance body should continually update code of professional conduct to eliminate auditor intent to make a fraud.
Was found guilty on negligent misrepresentation and fraud. For negligent misrepresentation made with the intent to induce plaintiff to rely on it. So, author has intention to do that to get some benefit from certain transaction. The court used restatement second of third rule to allow the plaintiff to recover if the plaintiff was within the class of person that audit was intended to benefit for a particular transaction to the audit. The court found that Billy was in the group and recognized Arthur knows what he did is wrong. Next is fraud. Auditor liable to the third party because the auditor intend to defraud them. For this case, plaintiff win, which is Billy. The court give compensation to Billy about $4.3 million, which is 75% from every investment he made.
In conclusion, for Billy v. Arthur Young & Co., Billy does not give auditors an arbitrary advantage by limiting their liability. Rather, it strikes the proper balance between traditional principles of tort law and the realities of the modern marketplace. Legislation will fairly apportion liability without undercutting commercial relationships. If the legislation should tie the auditor's standard of care exclusively to GAAP and GAAP so that auditors have notice of the conduct for which they may be held liable. Therefore, this is the best approach for auditors, those who use audit reports and the general public.
Rosenblum acquired some stock after negotiation with Giant. After a year, Rosenblum has took a legal action against Torch, the Giant auditor, because they are illegally relying on the correctness of the audit, acquired Giant common stock in conjunction with the sale of their business to Giant. The stock seemed proved to be worthless after they found out that the financial statement is under fraud. So the plaintiff declared that their loss is presumably caused by the Torch that is liable for negligently in conducting the audits.
For Rosenblum versus Adler, first rule, judge may consider economic situation. They think there is a contributory negligence, so Adler is also at fault. But second rule, shown Rosenblum is directly affected by defendant act, and auditor must aware that their opinion can influence Rosenblum's decision. Recommendation, auditor must have professional skepticism, always ask and investigate Adler on any suspicious transaction. Auditor should be cautious to perform their skill and care by work in detail. Must understand Adler nature business and deal with client that poses integrity, not hiding any problem.
Of Report Audit 1971, the court dismissed Rosenblum's allegation in claiming the audit report has negligence. This is because the defendant's audit had been completed on April 16, 1971, and Giant's merger discussion with the plaintiff did not begin until the following September. Therefore, the defendant had no knowledge about Rosenblum were a member or the prospective merger at the time of the preparation of the audit. For the case to Report Audit 1972, Rosenblum claimed that there are fraud and negligence in audit report about merger agreement. The defendant said Rosenblum had already signed and were bound by the merger contract executed on March 9, 1972. At that time, the audit was issued in April 1972. Merger agreement, Giant represent and warranty that there will be no material adverse change on its business, property, or asset at the time closing date. The court said that the disclosure might have exposed a fraud on the part of Giant. Since the defendant were familiar with the merger agreement and had been engaged by Giant to audit the books and records of the plaintiff enterprise for the purpose of the merger, the trial court properly denied defendant's motion.
The conclusion of Rosenblum versus Adler. In this case, litigation against accountant is increasing. the decision professor to remove the privity bar of Altramas. The court's extension of the auditor's duty occurred in a case that did not require such overbreak. The Rosenblum decision protects lender and supplier who are necessary to the efficient operation of the commercial work. The accounting profession is self-regulating. If the Rosenblum court perception are valid, the opinion will be cause a domino effect in other jurisdiction. If its assumption is incorrect, others country will be ignored it.